You're listening to Audiology. Support our work on Patreon, and be sure to submit your requests for topics in the comments below. In the United States, the concept of disparate impact refers to situations where certain practices in the workplace, in housing, or in other areas negatively affect one group of people more than another. This occurs even if the rules or policies set by employers or landlords do not appear biased on the surface. Generally, laws at the federal level identify characteristics like race, color, religion, nationality, sex, disability status, and a few other traits as protected. This means that any negative effects from policies or practices that disproportionately impact people with these characteristics could be legally challenged. Under the Civil Rights Act of 1964, specifically Title VII, if an employment practice or policy significantly harms a group with a protected characteristic more than others, it could be in violation of the law. Title VII aims to prevent employers from implementing policies that, while they might appear neutral, end up having a discriminatory impact on protected groups. Even if there is no outright intention to discriminate, if a policy or practice ends up doing so, it can be challenged legally. However, an employer can defend themselves by showing that the practice or policy is directly related to the actual requirements of the job. This is known as the business necessity defense. Although not all civil rights laws explicitly cover disparate impact, the federal government can still pursue these claims under certain acts. Notably, the U.S. Supreme Court has recognized that both the Age Discrimination in Employment Act of 1967 and the Fair Housing Act of 1968 allow for legal action based on disparate impact. This legal landscape shows a commitment to ensuring that employment and housing practices are fair for everyone, not just in their intentions, but in their actual effect. Disparate impact is a concept in the law that falls under Title VII. This theory is about whether an employment practice negatively affects a group of people protected by Title VII. When we talk about adverse impact, we're focusing on one particular part of this theory. It essentially examines how certain hiring or promotion practices might unfairly disadvantage specific groups based on their race, sex, or ethnicity. The method for determining if there's an adverse impact involves seeing if there's a significant difference in the rates at which different groups are selected for jobs or promotions. This difference is often assessed using something called the 80% rule, along with various statistical tests to ascertain if the difference is meaningful or significant. The terms adverse impact and disparate impact are frequently treated as though they are interchangeable. This concept really came into the spotlight with a landmark U.S. Supreme Court case in 1971, Griggs versus Duke Power Company. It's important to highlight that the presence of an adverse impact doesn't automatically imply that someone from a majority group is being favored over someone from a minority group. However, it does suggest there might be potential discrimination in the hiring process, and that could certainly be a red flag meriting further investigation. In 1971, a group of 32 experts known as the Technical Advisory Committee on Testing, or TACT, was brought together by the State of California Fair Employment Practice Commission. They worked on creating guidelines for how companies should select employees. By October 1972, they introduced what's now known as the 80% test in a groundbreaking document called the State of California Guidelines on Employee Selection Procedures. This test was a way to spot unfair treatment based on the numbers. Basically, it helped figure out if a company was discriminating against certain groups during hiring. The idea then got officially adopted into the 1978 Uniform Guidelines on Employee Selection Procedures. This important document guides the U.S. Equal Employment Opportunity Commission, Department of Labor, and Department of Justice on how to enforce fairness in hiring under Title VII. Let's break down how the 80% rule works using an example. Imagine a company, let's call it XYZ Company. If this company hires 50% of male applicants but only 20% of female applicants for a job mostly done by men, that's a red flag. To see if there's a real issue, you compare those hiring rates. Doing the math, 20% is only 40% of 50%, which is way below the 80% threshold set by the guidelines. This indicates that XYZ Company might be unfairly favoring men, and they'd need to show a really good reason for such a big difference in how men and women are being hired. However, since the 1980s, some have questioned whether this 80% rule is the best way to spot discrimination, leading to less reliance on it over the years. A memo from the U.S. Equal Employment Opportunities Commission in 2007 suggested a better approach might be to compare a company's hiring rate to what would happen if they chose applicants totally at random, which could offer a stronger defense against allegations of unfair hiring practice. The idea that small differences in job selection rates can still be considered unfair or adverse impact was first brought up by Section 4D of the Uniform Guidelines. This section explains that these differences matter when they are significant not just statistically, but in practical terms as well. This concept has been put into practice in several federal court cases, where the courts looked into how stable or reliable the adverse impact results were. They often did this by imagining what would happen if the people who were initially not selected, referred to as failing, were instead considered as passing. Some notable cases where this approach was used include Contreras v. City of Los Angeles from 1981, U.S. v. Commonwealth of Virginia from 1978, and Wysome v. Port Authority from 1991. Disparate impact refers to a form of discrimination that occurs not because an employer intends to discriminate, but rather when the same rules or methods are applied to everyone. Despite this, these rules can lead to significant differences in job outcomes for certain groups, even when these differences are not linked to the individual's ability to perform the job. It is crucial to understand that disparate impact on its own is not illegal. It becomes unlawful only if the employer cannot demonstrate that the practice causing the different outcomes is essential for the job and constitutes a business imperative. This justification for the practice is known as the business necessity defense. The concept of disparate impact also becomes relevant when discussing housing under the legislation known as the Fair Housing Act, which is a part of the Civil Rights Act of 1968. Here's the detailed explanation. All 10 federal appellate courts that have reviewed the subject concur that a violation of the Fair Housing Act can be demonstrated through the theory of disparate impact. Essentially, the United States Department of Housing and Urban Development, overseeing the Fair Housing Act, established guidelines in 2011 on how it applies the disparate impact approach in handling Fair Housing Act cases, cementing this approach with a final decision in 2013. Before the year 2015, the main query was whether the Fair Housing Act accommodated claims based on disparate impact. This question nearly reached the Supreme Court on 2 occasions, once with Magner v. Gallagher and again with Township of Mount Holly v. Mount Holly Gardens citizens. Nonetheless, both cases were settled, partly due to encouragement from the Obama administration, which, along with civil rights organizations, was concerned that a Supreme Court verdict might contest disparate impact arguments, potentially undermining the efforts to fight housing discrimination. Then, on June 25, 2015, the Supreme Court issued a pivotal ruling in a case named Texas Department of Housing and Community Affairs versus Inclusive Communities Project, Inc., declaring 5-4 that claims of disparate impact are indeed valid under the Fair Housing Act. Justice Kennedy, writing for the majority, emphasized that the acknowledgement of disparate impact claims is in line with the principal aim of the Fair Housing Act, to eradicate discriminatory practices in housing. He pointed out that addressing illegal housing policies which unjustly exclude minorities from certain areas is precisely what disparate impact liability aims to resolve. According to him, this recognition aids in uncovering hidden biases and subtle discrimination forms that might not be explicitly apparent. To succeed in a disparate impact case, there are 3 crucial stages. First, the individual making the claim, the plaintiff, must conspicuously illustrate how a particular policy or procedure directly results in unequal impact or a significant statistical disparity, identifying the precise policy responsible for this disparity. Next, the organization being accused, the defendant, is provided with an opportunity to prove that the policy in question has a significant, legitimate, non-discriminatory purpose behind it. And lastly, if the defendant is able to justify the policy, the plaintiff must then present an alternative manner to achieve the same objective that does not lead to discrimination. If the plaintiff is unable to do so, their claim of disparate impact collapses. This 3-step framework details the process of proving or disputing a case of housing discrimination based on disparate impact, concentrating on unfair policies that disproportionately affect minorities and offering a legal avenue to contest and amend those policies. The concept of disparate impact theory has sparked a lot of debates for several key reasons. At its core, this theory highlights that certain actions can be perceived as discriminatory, even if there was no intent to discriminate. Normally, we consider discrimination as an action taken with intention. Moreover, this theory occasionally conflicts with other civil rights protections and the United States Constitution, which guarantees equal treatment for all. Imagine a fire department that decides only those who can lift 100 pounds can apply. If this requirement disproportionately prevents a higher percentage of women from obtaining the job under certain rules, like the 80% rule, women could argue they are facing discrimination because of this rule, even though it was not designed to exclude them. In a scenario where the fire department then decides not to hire anyone to avoid being accused of discrimination because most of the qualified applicants were men, it would then be discriminating against those men, turning the situation into a different legal matter. This was somewhat mirrored in the legal case, Ritchie versus DiStefano, where the Supreme Court deemed a fire department guilty of incorrect discrimination when it attempted to avoid a discrimination lawsuit from another group. Justice Scalia even suggested this action might conflict with the Constitution's guarantee of equal treatment. Back in 2013, the Equal Employment Opportunity Commission fought against the common practice of using criminal and credit checks in hiring, arguing it was indirectly discriminatory since minorities are more likely to have criminal records or poor credit in the United States. However, United States District Judge Roger Titus was very critical of this perspective, emphasizing the dilemma employers face: ignore these checks and risk hiring someone who might commit crimes or face complaints from the EEOC. Judge Titus called for a more solid foundation before making such a discrimination claim, underlining that abandoning common sense is not the intention of the law. Furthermore, thinker Thomas Sowell has challenged the assumption that disparities in success rates automatically indicate discrimination, considering this thought process flawed. Thanks for watching. Share your thoughts in the comments and subscribe for more content.